Hi, I'm Donna from Cultural Banker. I'm here today with the Real Estate Connection, and my guest today is Joseph Stargiotti of Stargiotti and Beatley Attorneys here in Pleasantville. They have an office right on Wheeler Avenue. Hi, Joe. How are you?
Hi, Donna. Thanks for having me.
Nice to have you here. Today, I would like to ask you some questions about buyers and sellers and what they need to do to get their proper documents ready to transfer title of their home. And this, of course, is after the process of a homeowner finding a buyer and both people getting their attorneys. So I wanted to talk to you from the buyer's point of view and what a buyer needs to do, if anything, to be able to move forward purchasing a home they have chosen. So they have had their inspection already, they've picked their home, and they're at the point where they want to sign a contract.
Sure.
So you, as a representative of a buyer, what would you expect to get from a seller? Mm-hmm. Would you get a contract from the seller, and what would the buyer expect?
Right. So the first thing that happens is that the seller's attorney would typically prepare a contract, and there's a standard form New York State contract, but every lawyer likes to put on their own rider, which modifies the form contract to meet the terms of the specific transaction. And so I would typically receive that and review it, go over things with my client, make sure that the price is right, that the down payment that was agreed upon is right, that my client understands what's included with the sale. That's a big issue. Sometimes they don't realize that the dining room chandelier is going with the seller. So they should know what's included with the sale and what's not included with the sale, which we can talk about more in a minute. And then I'll typically review things with them. What happens if, for example, the house burns down between the contract and the closing? There are times when that happens, and you typically can get your money back.
Okay.
And cancel the deal. And there are things about a contract that don't really involve the transaction per se, but the what if this happens or what if that happens, like what if the house burns down. So I'll go over that with the client and make sure that the client understands what is going on. The most important thing for a buyer to do, though, is to make sure that they have their financing. And financing typically is a mortgage. Typically, a buyer would have a certain amount of their own cash that they are willing to spend on the house, and then the rest is borrowed in a mortgage. Most transactions involve a mortgage contingency, and that's provided for in the contract as well, that says something like the purchaser's obligation to buy the house is conditioned on them getting a mortgage in X amount, the amount that they need, within a certain period of time, typically 30 or 45 days. They have to get a mortgage commitment. Their obligation is to make an application promptly, to diligently pursue it, to provide the lender with whatever documentation they require. That's the buyer's responsibility, so you should put all that material together early, if not before bidding on a house. It's a good idea. You know you're going to have to borrow a certain amount of money. Put together all your financial information. Might even be a good idea to talk to a lender beforehand and ask them, what will you need from me on a mortgage application so that you can be prepared.
Right. I find that many of the buyers that are now very savvy have done most of that work even before they get to me. They don't usually wait quite that long when they have a contract before they'll go get those documents put together anymore. Right. I do find most of my buyers have already gotten all their stuff together.
However, lenders will typically give one of two kinds of documents. There's a pre-approval and a pre-qualification letter. Pre-approval letter is merely a letter that says, the lender says, you qualify or you will be able to afford this amount of loan. So let's say you want to borrow $300,000, and you go to a lender and you show them your income tax returns from the prior year, and the lender can give you a letter that says you'll be able to afford $300,000. It's not a formal approval. It is merely an opinion, an early opinion that you can afford that. So that when you make a bid on a house, you can show that to the seller or the seller's attorney or the real estate agent, and you say, look, I know I'm qualified for the $300,000 mortgage that I need to get. That does not mean that you don't have to go through a formal mortgage application process, and you need to get a commitment. And there's a lot more to the underwriting, the valuing of the house by the bank, making sure that you have all the appropriate assets that you need in order to formally qualify for a commitment. And that's why it's important, even with a pre-approval letter, or even a pre-qualification letter, which is a little bit more formal. You go through an underwriting process. It's not just a banker giving you an opinion. They actually underwrite you for a pre-qualification letter. It's a better, stronger negotiating tool for a buyer to have a pre-qualification than a pre-approval letter. However, it's important to have the conditional contract, the contract that says that your obligation to buy is conditioned on you getting a commitment letter, because if for any reason you go through this application process and the bank denies your application, you have a window of time built into the contract to cancel the contract and get your money back.
Yeah, let's talk about one of those contingencies that isn't normally a contingency. I have seen this a few times lately, and usually when I do a negotiation and I prepare what we call a purchase memo, which has the points to the transaction in it that I pass off to an attorney to you. So on behalf of my buyer, I would put the price and the down payment and what's included and not included, pass that off to you so you all know what to expect in the contract.
Right.
But I find that some agents and some attorneys would like an appraisal contingency in a contract. How do you feel about an appraisal contingency in a contract?
Well, if a buyer, it depends on the mortgage contingency. So a mortgage contingency includes an appraisal contingency because the lender can deny you your mortgage commitment if the house doesn't appraise high enough.
Right.
And so it's sort of built into that process. Certainly, though, if you're buying a house without a mortgage or without a mortgage contingency, be typically called an all-cash deal.
Right.
Okay, they call it all cash, even though you might be borrowing money, but your obligation to purchase is not conditioned on you getting a loan. Then I would want an appraisal contingency, because if you're buying a house for $700,000 and it only appraises at $6,000, you may not want it.
Right.
Now, the appraisal contingency can have different forms. It can say, well, if it doesn't appraise high enough, if it doesn't appraise for the purchase price, I can cancel the deal.
Yeah.
Or it could say, if the house doesn't appraise high enough, then the purchase price will be reduced to the appraised value.
Yeah.
That way, the seller is more, and maybe the seller has the opportunity to then cancel the deal. Everybody wants to protect themselves.
Right.
And so what form that appraisal contingency takes depends upon the negotiated terms of it between the lawyers and everybody looking out for their own client's interest. Nobody wants to buy a house. And I will tell you, there are times when somebody says, I know that the house may appraise lower than I'm paying for it. I want it anyway.
Yeah.
Because they love the house, and they want the house, and they know they're going to be there for a long time.
Yeah.
So if they're buying it for $7,000 and it appraises at $650, but they know they're going to be there for at least 10 or 15 or 20 years, they're planning on sending their kids to the schools, and that's their future plan, they feel comfortable that the house will be worth more later anyway. So you have to talk to your lawyer, or I would say from my perspective, I need to speak with my clients and find out what their plan is.
Well, too, you need to know which direction the market is going, because if the market's going up, a similar house that comes on may actually end up selling for more.
Right.
If they pass up that house because of the appraisal, maybe another comparable house would sell for that price or more anyway, so maybe they would be willing to pay that price now.
Right.
Yeah.
So when it comes to the mortgage contingency, it's important to speak to your lawyer, get a good understanding of what your rights and obligations are.
Yeah.
But the most important thing to understand is that with a mortgage contingency, if you don't get your mortgage by a certain date, then you have an opportunity to cancel the contract and get your money back, because typically people are putting up a lot of money. When you're talking about 10% down on a contract and you're buying $700,000, that's $70,000 being held in the seller's attorney's escrow account for the purpose of binding the deal, binding the transaction. But if you don't get your mortgage and you can't close, you need to be able to get that money back.
Right.
That's the most important thing. Once you have that, what form it takes is really just a matter of, negotiated terms between the parties, and that's and that's fine. And I do that, frequently for clients where we'll negotiate different types of contingencies based on their outlook and their expectation from the transaction, and it might include a separate appraisal contingency as well.
Okay, and I want buyers to know too that when you do go to the closing with this mortgage that you have, and you have 5 inches of paper to sign, that your attorney, Joe, will go over every page of that mortgage.
Right. So I have different kinds of clients.
Yeah.
Some clients buy and sell real estate frequently.
Yeah.
And they're familiar with it. So I don't need to go over every single document with them. But when I have a client who wants me to sit at that table and go over each document, I spend that time. That's what you need to do. I mean, that's to my thinking, that's what I do for a client. I bring my knowledge and expertise, but also my time and my connection to them, to the transaction. I want them to feel comfortable. I feel that my goal is to make the transaction as pleasant and painless as I can. There are some times when things happen where it's a little bit painful. For example, you have a closing date set, and then all of a sudden the seller says, I'm sorry, not closing that day, we're going to close a month later.
Oh.
And the buyer says, wait a minute, how can I close a month later? I'm moving out of my apartment, my kids are starting school, I need to get into this house. So there are things that do happen that can be stressful.
Yes.
My job really is to try to minimize that stress and close the transaction as expeditiously and painlessly as possible.
Okay. So usually when I have a buyer and we have done our inspections, certain things come up in the inspection that may or may not be included in the contract. But I just wanted to get your opinion, and this is even information for homeowners as well. Mm-hmm. I've had situations where we do an oil tank test. The tank is in the ground, and we do a test, and the tank is okay, it passes.
Right.
But the buyer wants the tank out anyway.
Right.
How would you handle something like that?
Well, typically I would first go to the seller's attorney and tell them, we would like your client to remove that tank before closing.
Yeah.
Now that seller might say, I'm sorry, I'm simply not going to do that.
Yeah.
Or they might say, yes, I'm willing to do that. Or they might be able to put in an insurance claim, because oil tanks now in the ground are really considered problematic. Even if they're not leaking, they may leak someday, and you may be able to make an insurance claim. And it's cheaper to take it out of the ground when it's not leaking than after it does leak. Because once it leaks and there's oil in the ground, you have to have it tested. You have to make sure that it's clean. And if it's not, it has to be properly remediated, which means the contaminated soil needs to be taken away and properly disposed of, which is expensive. So a seller might be willing to do that. Or they might say, hey, let's split the cost. It's going to cost $12,000. You will reduce the purchase price by $6,000, and I'll pay the $12,000, but we'll reduce the purchase price by $6,000, or increase the purchase price by $6,000 in order to split the cost. So there's a negotiated solution to that problem.
Yeah.
But at the end of the day, the buyer needs to know that they want to buy the house. So if there's an oil tank in the ground and they don't want an oil tank in the ground, and the seller says, I'm not taking that oil tank out of the ground, and the buyer says, well, I don't want to take that oil tank out of the ground, or take the risk of closing the transaction and then later taking it out and finding out there's oil in the ground, then don't buy the house. I mean, there are certain things that a buyer needs to know. That is the deal breaker. It's a deal breaker for me. It's not something that I'm going to be able to manage after I close, and I don't want to do that. So there are a few things like that. The oil tank in the ground is like that. Most other things are more visible. So you'll know when you do an inspection and the inspector tells you that there's a cracked rafter. It's probably not that hard to repair, to be perfectly honest. A carpenter can repair that. So a seller will be willing to do that, or probably a buyer would say, look, that's okay, we'll buy it with the cracked rafter. I'll have a carpenter come in later and repair it.
Right.
That's fine. Most things are more visible.
Okay. All right. Thank you. So now we have a happy buyer. They've gotten through the closing after sweating. And they have this wonderful asset they have a good chunk of equity because they've probably put down 20% on it, most likely.
Mm-hmm.
How do they protect that asset, and what do they do legally going forward with the mortgage that they now have and their family, and what would happen next, do you think?
Well, I mean, typically people just settle into paying their mortgage. You have to know you have taxes, insurances. There's always going to be homeowners insurance to purchase. One of the things we do to protect an asset, and it's one of the things that people do not really understand that well. People understand homeowners insurance, casualty insurance, that in the event the house burns down or gets hit by a tree or falling tree or something, it can be repaired. One of the insurances that people buy at a closing that they don't really understand is title insurance, but it's an important insurance where a title company will search the records to see if there are any liens or judgments or easements on the property, and they insure you that when you buy that house, that you own the house, that your mortgage is the only mortgage on the property, that there are no liens or judgments, and that there are no easements or rights of way that interfere with your ability to use that house as it is built as a single-family house. So, for example, utility easements are customary and they're common, and they're not considered easements that interfere with the use of the house. In fact, they facilitate the use of the house because the utility has wires and pipes going to your house, so that's fine. So it's important to work with an attorney who understands title insurance and making sure that the quality of your ownership is important. So you're starting off with a physical asset, but also a legal asset that you really own.
Can we just talk about fences?
Sure.
Okay. I have had situations where fences come up in the title report as either being on the property line.
Right.
Title companies, I don't think they necessarily like that so much, or maybe they're an inch the wrong way.
Right.
If they're on the line, who owns the fence?
How about this one? If you really want to split hairs, one property owner owns this side of the fence and the other property owner owns that side of the fence. But it's very uncommon for a fence to be actually on a property line for any distance. They cross property lines frequently, and they're usually within a few inches of a property line. Those are not really title problems. It's a title issue, but it's not a title problem.
Yeah.
And the reason is because there's a rule of law in Latin. It's de minimis non curat lex, meaning it's so small you don't need to cure that, and nobody loses their title ownership of the property on the wrong side of the fence.
Okay.
So if, for example, you own a piece of property and the fence is on your side of the property line by 6 inches, that's de minimis.
Okay.
And the property that's on the other side of the fence, on your neighbor's side of the fence, but on your side of the property line, you do not lose ownership to that.
Okay.
And the question would become, what's a reasonable distance? And if anybody chose to try to litigate that, a judge would have to decide. And to be perfectly honest, it would be very, very unlikely that in any situation like that, whether it's 6 inches, 8 inches, 12 inches even, that some judge would decide that that property is owned by your neighbor.
Okay.
But when you have a significant portion of your property that is outside of your fence, between your fence and your property line, and you cannot access that property through the fence without going outside the fence to come around to it, you could lose ownership. That's called adverse possession.
Okay.
Where somebody else uses your property openly, apparently you know it, and you haven't given them permission. That's a significant element of an adverse possession claim.
Mm-hmm. Okay.
If you give them permission, you write them a letter and you say, I know that my property's on your side of the fence, and I know that you're using it as part of your yard, and I give you permission, but you're not going to gain any adverse possession rights.
Yep.
They'll never gain adverse possession rights. Adverse possession has to be 10 years, openly, notoriously, under claim of right, without permission. So there are certain things. There's another way to solve that problem, and that is put a gate in the fence. If there's a gate in the fence, so let's say your backyard, you have a fence, and there's 20 feet beyond the fence. That is your property, but it's outside the fence. If there's a gate in the fence where you can open the gate and walk onto that property, you're not out of possession. It's not considered out of possession. It's not out of your possession. So you can solve that problem by putting a gate
Okay,
in.
New information for me. Thank you.
And, but there is an important thing to consider, and that is the 10-year period for gaining adverse possession rights does not have to be by the same owners. It can be tacked on owner after owner after owner. So, for example, if there's a fence and you have 20 feet of your property on the other side of the fence, and the other property has had 6 owners over the past 10 years, and the property you're buying has had 6 owners over the past 10 years. It doesn't matter. You can still lose out. When you buy it, you need to make sure when you buy it that nobody else has any ownership rights. And frequently, when we have that situation, I'll go to a neighbor and I'll say, look, we would like you to sign this document that says you're not making any claim.
That makes sense now. I had that issue where I had to get 3 neighbors had to sign off because the fence was all in the wrong place every which way.
Right.
And it took a while, but yeah.
But I'll tell you what, a common situation, though, is where a fence crisscrosses a property line. It's not straight, and it goes, it's on their property by 3 feet on this end of the fence, and it's on 3 feet of the property on the other end of the fence, and it crosses the property line because whoever put in the fence didn't pay attention to the property line.
They went around a tree or a bush or a rock.
Right, and in that situation, we might get something called a property line agreement, where I'll go to the neighbor, typically the seller's attorney, would go to the neighbor and say, look, my client is selling this property. We'd like a property line agreement. It protects you, and it protects them. And the neighbor is frequently willing to sign that because it's true. It benefits them in the sense that they're not losing any property, and it benefits the seller of the house because they're not losing any property or potentially losing any property because the fence is so cockeyed that it can be bad for both parties. So it's in both of their interests in order to resolve that to sign a property line agreement that says, look, we each agree from now and in perpetuity, we each own what's on our side of the property line, regardless of where the fence is. You know,
so straighten that out.
There are the point is, though, there are different solutions. I will say, from a real estate attorney's perspective, it's important to have a lot of different tools to solve different problems, because you never know what kind of problem is going to come up in a particular transaction. You get that title report and you start reading it, and all of a sudden you see a mortgage that's 40 years old, and that owner hasn't lived there in 20 years. But you need to be able to solve that problem, and we can. I mean, there are lots of things that can be done about that. Property lines, title issues get resolved that way all the time. You just need lawyers, typically lawyers and title agents, who can devise the appropriate solution and implement that appropriate solution so that when we close finally, title is good and the buyer owns what they expect to own.
So when you get a contract, do you research the title at that time, or do you wait until the mortgage commitment comes in? At what point do you ask for the title research?
As soon as I get a contract signed. So the contract is a contract when both parties sign it, the down payment check has been delivered, and the contracts have been exchanged so that both parties have a fully signed copy of the contract and the seller's attorney is holding the down payment. On that day, that's when it becomes a contract. And typically on that day, I'll call a title agent and order a title report. And it takes about a week, maybe 10 days to get a title report, and then I review it thoroughly. I don't just, I got the title report, cast it aside, because you never know what's going to be in there. You have to look at it. And I will say that I think that there are a number of attorneys out there, and I don't mean to be disparaging, but they just don't look at them. And you really have to look at it. So, but we do it early in the process, just right after the contract. That way, when the commitment comes through, we can send a copy right off to the bank attorney because they need a copy as well. And we want to be prepared.
And everything gets cleared.
And everything has to be cleared, and sometimes that takes time.
I know.
So you need to get it early. You can't get a title report 3 days before the closing. It's too late. It might be too late. It might not be. There might be no issues, which is fine, but you don't know, and that's the whole point of the title report.
Okay, we have just a few minutes left, but let me just ask you about the new rules to getting your documents ready to close. You need your facts and figures to file your paperwork. You need 3 days or something new now with the new rules for closing.
So there used to be the agency, Department of Housing and Urban Development, that oversaw the implementation of a federal law called the Real Estate Settlement Practices Act, RESPA.
Right.
And they had regulations that included, many people have heard of the HUD-1 settlement statement. That was the old form that we used for decades, the HUD-1 settlement statement. And the HUD-1 settlement statement, you could make changes at the closing. Typically, if there were errors on it, nobody really cared much. It was not something that was enforced, but it all involves consumer protection. The point of the form is so that a consumer can look at it and know what happened at their transaction 5 years ago, 10 years ago. And because of the problems that developed through the course of 2008 and 9, the federal government wanted to implement more protections for consumers. They created a new agency called the CFPB, Consumer Finance Protection Board.
Okay.
And CFPB has now taken over implementation of the law, the Real Estate Settlement Practices Act.
Okay.
And they created a whole bunch of new forms. Instead of a HUD-1 settlement statement, there's a closing disclosure for a buyer, a closing disclosure for a seller. Instead of what used to be called the estimate, the good faith estimate, now they have a loan disclosure. And there are some other documents, and there are time windows that require those things to be delivered to the consumer in very short order. So when you make a mortgage application, you're entitled to a loan disclosure within, I think it's 5 days.
Okay.
Of making the application. And what an application is very specific. And that way you can have an idea of what your costs are going to be early in the process. You're also entitled to a closing disclosure more than 3 days before the closing. That lays out your cost basically to the penny. There are certain situations where a change can be made, but most not. It usually involves things that are discretionary with the borrower and who is the buyer. If there's a change to the contract, you can within the last 3 days you can change the closing disclosure. But the lender is not allowed to change anything.
Okay.
And if the lender's actual cost to close is higher than what the loan estimate said and what the closing disclosure says, the bank actually has to pay it.
Wow.
So, for example, if they estimate your title charges at $4,000 and it happens to be $4,500, they have to pay the $500.
Oh.
Okay, but it does.
That is consumer protection.
It's consumer protection, and there's a board that you can call called it's the Consumer Protection Finance Board, and you can call them if you have a problem, and you should be able to get somebody on the phone to investigate your situation and enforce. And they're being very tough on banks, and I've represented a number of banks where something was not properly disclosed, and it cost the bank quite a bit of money.
Wow. Okay.
You know, so.
Okay.
And by the way, lenders' attorneys, which I am a lender's attorney as well as I close loans for lenders, sometimes things come out of my pocket. So, well, they don't because I make sure that they're right.
Right.
You make sure that they're right.
Yeah.
And that's all. If you make sure that they're right, it won't cost anybody anything.
Right.
But the point is the consumer is entitled to know and know early. The 3-day window cannot be waived, so frequently it holds up a closing. We send out or the lender will send out a loan disclosure. We'll have to select a date to close 5 or 6 or 7 days down the road.
Okay, so you
So
build
that you
in
can
some
then,
time.
so then they can work up their closing disclosure and serve it on
Right.
and send it to the consumer. There used to be a time when people would say, "I got this deal. I want to close it in 2 days." Nothing is done like that anymore. We cannot close a loan in 2 days.
Yeah.
It doesn't happen. Can't happen. But it's for the consumer's protection. And it does work. So, you know, we real estate professionals need to be familiar with it. Lenders' attorneys, buyers' attorneys, and sellers' attorneys should be familiar with it as well because you want to protect your clients.
Right.
You know, so there are a lot of new rules and regulations, and there's probably that much of, you know, a guide. And if you have any question, you can flip to the right page in the guide and find out if in a particular situation you can make the change or you can't make the change. Does the consumer get the money from the lender or not?
Right.
You know, when can you close? How do you serve things? It's all right there in black and white, and it's pretty clear. And I think it works better than the HUD-1 settlement statement used to.
Oh,
It was hard change.
That's good to hear.
It was a hard change for
Yeah.
all of us to make, but it was implemented in October of
Yeah.
2015.
Yeah.
You know, and
We've been living within that. Now it seems
No, it's the
seamless,
norm.
but yeah,
it's
right.
the norm now. You know,
Right.
it takes a little while, but once you use it for a year and a half,
Yeah.
it's the norm.
Okay. All right,
know.
Joe. Joseph.
Thank
you very much. Thank you for coming on the Real Estate Connection. I'm Donna Edlund. I think we might have to have another chat with Joe. There's a lot more to cover, so maybe we'll have a part 2.
It was my pleasure to be here. Thank you.
Okay. Thank you.